Hello and welcome. Today I'm going to be discussing what fees can be paid by the employee. So hopefully you can see that. What fees can the employee pay? Whenever an employer files a H-1B, there's a number of fees associated with that filing. There's a $460, which is the basic filing fee. There's a $500 fraud fee. And then there is a training fee, which is dependent on a number of employees, and that ranges from $750 to $1,500. In some cases, there's also a $4,000 public law fee. There's attorney fees, which obviously vary from attorney to attorney. And then if the employer or the employee chooses to file in premium processing, there could be an additional $2,500. If the H-1B applicant has dependents, there could be H-4 costs, and that includes a $370 filing fee. So what the regulations state is that any fees associated with the H-1B filing are essentially considered to be business expenses. And what that means is that the employer has to pay those fees. So that includes the filing fees, it includes the attorney fees. In terms of the premium processing fee, it depends on who wants to file in premium processing. So if the employee is the one that wants to file in premium processing, it's okay for the employee to pay that fee. However, if the employer is the one insisting that it gets filed in premium processing, the employer should be the one to bear that cost. In terms of the H-4 costs, because it doesn't necessarily directly relate to the H-1B, the employee can pay those costs. So what that also means is that the employer can't try and recoup those costs. Whenever we file a H-1B petition with immigration, we typically include an employment agreement. So if there's anything within that employment agreement where the employer is trying to recoup costs related to the H-1B, if USCIS sees that, they can deny the application. So the employer needs to make sure they're not asking the employee to repay those costs in the event that they leave the employment. In terms of the green card fees, so for employment-based green cards, you have the PERM process, which is also known as the labor certification, the I-140, and then usually the 485 if the person is adjusting status within the US. Again, the regulations are very clear. The PERM fees have to be paid by the employer, which typically include the attorney fee and the advertisement costs. For the I-140, in addition to the attorney fee, there's a $700 filing fee and a $2,500 premium processing if it's filed in premium processing. For the 485, in addition to the attorney fee, it's a $1,225 filing fee, $750 if under 14 years of age. So the I-140 and the 485 fees can be paid by the employee. For example, I spoke to a potential client the other day. They had left the employment and the employer was seeking to recover the cost of the I-140 and the 485. They were not seeking to recover the cost of the PERM fees. I advised that client that, that agreement was perfectly reasonable. The employee had signed the agreement. It was perfectly valid because they were only seeking to recover the I-140 and the 485 fee. If an employer tries to recoup fees they're not entitled to, H-1B fees, PERM fees, they could be subject to both penalties and sanctions from the Department of Labor. If you have any questions regarding this, please email me at cprescott@patellegal.com. Thank you for listening.